Good morning, my name is Mark Miller. I am the secretary for the Virginia Ability. This morning I've been honored to be able to present our annual legal update program. That's we're going to look at how our managers and people can work together to accommodate hidden or just non-apparent disabilities. Steve will talk about that, I'm sure. And when it's all over, we'll encourage everybody to complete that survey that you handed out. Please do that. It helps us to kind of see judge how things go. Steve is a partner at the law firm. Is IslerDare,
yep.
And he's our featured presenter today. He brings over 30 years of legal expertise to you guys, whether he's tackling everyday issues or leading a 2-week jury trial. He focused on achieving practical solutions for his clients. He's all done with everything. In the last 15 minutes, we'll have a little Q&A. And you guys can ask questions and talk to him about that. So if everybody's good to go, we'll let Steve start.
All right, let's get rolling. So first thing will be the yellow elephant in the room. So I'm just gonna let you go. That is a bulb in the projector issue. So I did not color on this. My kids are all grown, so I have grandkids now. They're not at the house, so nobody used a highlighter and color. It looks like I did. If you look at this, it's got little bottom parts. It looks like somebody colored it. It's the bulb. The bulb was left on in the projector too long, and so now it's in whatever mode it's in. So we're going to have this little bit of a shadow. So it'll keep you awake. I'll keep you awake anyway. But at the bottom, so I just want to let you know that it's not there for any reason. I didn't want you to be thinking the whole time, what is he doing with that yellow stuff on this thing? It's not me. All right, so here's the agenda for today. You have the handwritten material as well. I don't read these slides to you. I will go through different highlight pieces in the slides. I try not to do that because it's really boring if people do that. If you have questions during this, you can feel free to ask. I don't care. You're not going to mess me up. If you want to wait till the end, that's fine too. But either way, if something's bothering you and you really got to get it out and you want to talk, then just raise your hand and tell me. It's perfectly fine. So we're going to go through the basics of the ADA. We're going to talk about invisible and hidden disabilities under the ADA. What the responsibilities are for the employee in the process, as well as the responsibilities for the employer. What we forget about a lot of times during the interaction between the employer and the employee is both sides have to actually work together. And a lot of times I hear from HR, I can't get the employee to tell me. Or, she's refusing to tell me. I mean, I have an example now that I can tell you before we get too far into this. We've got somebody now for one of my clients that we believe has a disability, but she won't tell us. And she just won't come to work. And so the issue we're having now is, will you go to EAP? We're trying to pay for you to go to the employee assistance plan. Can we talk to your dad? Can we talk to your sister? Can we talk to somebody? Can we help you get to a medical professional? And she said, there's nothing wrong with me. But there is something wrong. She's for 10 years been wonderful. And now she took off 2 weeks ago, didn't come to work, and drove to New Jersey and didn't tell anybody. And so we're trying to call her, and she goes, I'm in Jersey and I don't know where I am, I'm lost. And so we know there's something going on, but we don't want to be you're trying not to be too abusive about it. Abusive's not the right word, but too intrusive. But we need to be, because something's not firing right in her head. She's never been late to work, ever in 10 years. And to get in the car and drive, so we called her dad. Her dad went and got her. They put her into an inpatient facility for a week. She came back to work for a day or two and then had another episode where she just disappeared for the day. So we know right now we put her on FMLA. She didn't want to fill the paperwork out. We just made her take FMLA. Because what we said to her is, we want to give you job protected leave. And she goes, I don't care about that. I said, well, I think you might. So we put her on job protected leave. We're trying to work through these issues with her. What's ultimately going to happen if she doesn't work with us, we're not going to be able to keep her. So you're going to hear a lot, and so that's a hidden issue. So that's kind of the employee not cooperating, the employer over cooperating, and really trying to make this work. Now, a lot of employers don't over cooperate. They go the other way. I usually get these calls from employers is, why do I have to help them out? I'm like, well, there's the law. And then there's kind of the nice part of what you should do as just a person. It's like, well, they didn't ask for anything, or they've asked for something that's unreasonable, and I find it's not unreasonable. Most of the time, in the cases I deal with, people aren't asking for unreasonable accommodations. Employers just don't want to do it. And we'll talk about why that happens and why they get themselves in trouble. So, then the last thing we'll do is a case study. I've got a case in here for you. That's a case out of Maine. It deals with a manager at one of the local auto parts stores. I think it's O'Reilly. And the issues he was having and how the employer easily could have settled this case and resolved it. You do not want to be an employer that's in a reported case. If you're an employer in a reported case, then we always refer to you by your employer name. And so, that's what happens all the time. And now you're in the history, you will always be referred to as X, and your name will always come up as being the bumbling employer that screwed this up. So we always try to avoid, at least in my practice, having those employers show up in those cases. You want to be in the cases you win, but you really don't want to be in the ones you lose. All right, so let's look at some of the headlines that are going on. There's an international study that estimates 40% of the people with disabilities have a hidden impairment. And you can probably think of people, either yourself or people in your family or your friends, everybody has this issue. My niece has some sort of migraine issue going on where she has auras and she blacks out. She just now got disability under the Social Security Administration, under the disability piece. She's 33 years old. She's had this since she was 18. And I finally got her to VCU Health. It took me 13 years to convince her to go to a hospital, because what she said is, well, if I pray about it, it'll be okay. And I said, nothing wrong with prayer. I have zero problems with prayer. But the way I looked at it when I was brought up is God helps those that help themselves, and that's what a hospital's for. So please go see somebody in the hospital. And finally this year she did, and they were able to help her. Well, it's a big miracle. I mean, it's not that big of a miracle. There's medical science that can help you. So I'm all big fan about praying, but for 13 years she prayed, and she had numerous issues where she crashed her car because she blacked out, and she couldn't go to the job. She had a number of issues. So her employer was very understanding for 2 years. She missed probably 8 days a month of work, and they didn't fire her. They even let her in her first year of employment get to the FMLA status, which I was shocked at. I thought for sure they would let her go before the 12 months because she was missing on average 2 days a week. But they worked with her. Now she's got disability, which is what she belongs. So she has a hidden impairment. There's tons of people that have these hidden impairments. Nearly 1 in 5 of the adults live with some sort of mental illness. We know that on a 20%, in your family, there's probably somebody that's dealing with mental illness somewhere down the road. We just all have it. So if 20% of us are dealing with that, you probably know somebody that is. Those with serious mental illnesses, such as depressive order, they're at the rate of almost 55%. So we're seeing a lot of mental illness, major depressive disorders, all kinds of things that are going on in our social system at this point. And you can attribute it to a lot of stuff. I don't think you can blame it all on COVID. It didn't help that we went through that 4 years ago. It really doesn't seem like 4 years ago, does it? It feels like it was 4 months ago, and then it feels like it was a lifetime. But 4 years ago, you remember what we were dealing with at this point. So June of 2020, nobody knows if there's going to be a vaccine. Nobody knows if we're all going to die from this. And so that caused a number of issues with a number of people, and we're still dealing with those types of issues. So let's do a little bit of the ADA basics. You probably don't need a whole lot of this, but I'm going to give you some anyway, because that's part of what we need to do, because you have to understand the ADA before we get into the rest of it. So the Americans with Disabilities Act prohibits discrimination with those that are qualified individuals with a disability. What a lot of people don't remember as part of the law is you got to be a qualified individual with a disability, meaning you have to be able to perform the essential job functions with or without a reasonable accommodation. If you cannot perform the essential job functions, you do not win under the ADA. It's as simple as that. Now, a lot of people mess this up and think, you know what, I've got to give everybody an accommodation, whatever they want. No, it's a reasonable accommodation that you have to give. So the way the law sets up is the qualified individual is somebody that can perform those essential functions, and then an individual with a disability is somebody that has a physical or mental impairment, has a record of that impairment, or is regarded as having that impairment. Now remember, the ADA is one of the few laws where you don't actually have to have a disability to win under the ADA. If you're regarded as somebody that has a disability and you don't, you're still covered by the ADA. So if people assume you have a disability, and this happens quite often, then you actually are covered by the law. So I always tell people the regarded as is the scariest part for me. It's much easier for me to defend something if it's a physical disability. It's harder on a mental disability or hidden disability. On the regarded as piece, it's extremely difficult to defend that type of a case because that's the way that people have perceived you in the workplace. So it's a hard thing for us to overcome. So what's an impairment? Physical impairment, we all know what that is. The mental impairment becomes a little harder to diagnose, kind of like my niece that I told you about, where we can't really tell why she's having these auras and what's going on with her migraines. Invisible disabilities, though, are those that are not immediately apparent. And they still have a significant impact on people's lives. Almost everybody knows someone or at least has probably something of a hidden disability because the 2008 amendments to the ADA broaden it out so that almost any type of condition you have may qualify. It wasn't like that before 2008. And I think when Congress put those amendments through, I think it was a good thing because it fixed a lot of case law that had come out between 1990 and 2007. Because in that time frame, there was a lot of cases that came out that were against people with disabilities, and Congress fixed a lot of that. So I'm glad that they did that because I think it's helpful. It's helpful from the employer side and the employee side. So if you don't know anything about my practice, I represent employers. I do not represent employees. But I'm still on the advocacy side for the employee with the employer because part of my role as the lawyer for the employer is to make sure they don't get themselves sued. And so I spend a lot of time advocating on behalf of the employee to make sure that the employer does the right thing. So there's tons of employee lawyers in town. I'm just not one of them, but I'm still in the vein of making sure we comply with the law and that we actually support and give people reasonable accommodations. But the ADA does not require that a disability be visible for you to have protection. And there's disability harassment, disability discrimination, and disability retaliation. You'll see some of that when we get to the case at the end. So the Amendments Act of 2008 again expanded everything out for folks. The key changes were they removed the requirement to consider mitigating measures when assessing substantial limitations. Now if you don't know what that means, back in the day, before it came out, if you had heart disease and you took a statin, that meant you didn't have the heart disease according to the law because you took a mitigating measure by taking a pill. If you had high blood pressure and you took a pill to help lower it, you didn't have a disability. It didn't make any sense at all. I mean, it's just dumb. But if judges are going to adopt that rule, and the Supreme Court did, that's the rule we argued. And so we were able to argue for 17 years that if you had mitigating measures that helped you out, you didn't have a disability. That's silly. The whole thing was silly, and the 2008 amendments fixed it. Recognizing episodic conditions, mental illness, HIV, cancer, things like that, and then evaluating substantial limitations, considering mitigating measures, very slightly. So if you wear eyeglasses, you're not considered somebody that's disabled, which makes sense. That's the mitigating measure that, to me, makes sense, but when people are taking medicine for issues and have issues like that, I don't think that makes any sense. So what's an essential function of a job? The duties or the aspects of the job that are fundamental to that job. There are very few essential job functions. We have long job descriptions. I mean, I review these 3-page job descriptions all the time. I don't know why they're that long. There's not that much to a job. There's just not. But employers love to write long job descriptions. They love to write long handbooks. I can't stand a handbook that's more than 20 pages. Most of them that I review are 40, 50, 60 pages long. I'm like, what in the world could you possibly have to put in something that's 60 pages long? If I'm not going to read it, the employee's not going to read it. And you're paying me to read it, so I guess I have to read it. But honestly, employees don't read it. So if I can get it down to 20, 25 pages, that's usually where your handbook should be. If you want to put some policies on the internet for people to look at, great. But your handbook you should be able to do in 20, 25 pages. Job description, page and a half at most. Because most of the jobs you have out there you can do in a page. You can say, there's no way, my job's so much more important. No, it's not. It's really not. We can get it down to a job. We can get down to a page. Then there's a fact-sensitive question. Whether something's an essential job function goes down to not what's in the job description if you haven't modified your job descriptions in a long time. It goes to what you're actually doing every day. So that's what the courts look at. The job description is great if you're going to keep it updated. It's a great piece of evidence, but if you're not going to update it, then it's going to be somewhat problematic. So I'll tell on myself. My secretary and I have been together now for 10 years this year. We opened this office of IslerDare 9 years ago. I think 9 years ago, 2 days ago. And she has a job description that started in 2014. It's completely morphed and I haven't changed it. Now, should I? Yes. Am I going to do it? No. I'm going to be just like every other employer out there that doesn't do what they're supposed to do. I should modify her job description to put all the other stuff she does, but I'm going to go with the catch-all that says you'll do anything I ask you to do, type of catch-all that I have in there. Yes, I should modify that. So now that I'm sitting here telling on myself and it's being recorded, I'm going to make a note to go back and make sure I change that job description probably in the next day or so. But a lot of times we just don't do it. And so she's so good on so many different things, but if she ever said to me, or I said to her, gee, you know, your performance isn't good, she's going to say on what category and which one. And she's going to have me dead to rights because her performance is wonderful and there's nothing I can do because the job description doesn't match. So when you're who's qualified, when you're evaluating whether you have a qualified individual, the EEOC has you look at a two-step approach. One, you decide if the person satisfies the prerequisites for the job. If you're okay, I'm going to take this thing off because it's annoying me. It's my little sticker. So if that's all right. And does he, she, they have the knowledge, skills, and abilities and education to do the job? And then you have to decide whether or not they can perform the essential functions of the job with or without a reasonable accommodation. Those are very easy things to follow, and a lot of employers just don't do it. Most people that you're going to interview are going to meet these requirements. And it's going to be folks that are with disabilities, whatever it is. But at the end of the day, these are the two things you should be looking at as an employer when you're vetting folks as to whether or not a person is qualified. How do you provide reasonable accommodations? Well, you have an affirmative duty as an employer to do it, as long as somebody tells you that they need one. And this is where it gets hard. We'll talk more about this throughout this presentation. But that's where I need both of you to dance. So it's like dancing with the stars. You can't just have one person on the dance floor. There's got to be somebody else with you. And so I need you to, the employee has to do it, the employer has to do it. But you do have an affirmative duty to reasonably accommodate folks. You're not required to, give them the accommodation that would fundamentally alter the essential functions of the job. And this is the pushback I get a ton from employers. And since COVID, it's happened a lot. And so when people want you to come back to work, the question I always have for my employers is, why? Do they really need to be back in the office to do the job? Or can remote work work? Well, it worked during COVID, but you told us during COVID that we didn't have to continue to do that, and the EEOC said that you can still make people come to work. I said, okay, I know I said that, and that's true. But do you really have to make them come to work? Are you going to retain them if you give them some flexibility? So at my firm, you don't have to come to the office. Even my assistants don't have to come. Now you're going to say, good Lord, how do you get something done? I give them enough flexibility that every Friday my legal assistants can alternate and somebody can work at home. I have 3 of them. So what I've said to them is, and if you need to work at home for some other reason because you got to take a child to the doctor or you have a doctor's appointment, we can make it work. What that's done for me is made more people come in. Which is kind of nice. And so I've got some people that never come in. I have a woman that works in Glen Allen that's been with us, and so she hadn't been in the office since February of 2020. And you know what? She's more productive now than she was before February of 2020. And so I don't want to mess with it. So the other day I hired a new lawyer and I called her and I said, hey, I'm going to give the office that you were supposed to go into to this new lawyer. And she said, well, that really bothers me. I'm like, why? I said, are you ever coming back? And she goes, no, I'm never coming back to the office, but I don't have an office now. And I said, you haven't had an office for 4 years. I said, we've been using that office for a variety of different things. It's a visiting attorney office. We have meetings in there. I said, it's not your office anymore. And I said, if you want to come in, I won't put her in there. She goes, no, I'm not really coming back in. It just bothers me. I'm going to lose it. I'm like, I get it. I understand. But I said, at the end of the day, if you want to come in, I've got a visiting attorney office. She's like, I can't use the one that was assigned to me. I said, no, I'm putting her in that office. That will be her office. But she's wonderful. And I'm glad she's enjoying where she is working from home because she's just a much better employee. When she came in, she was difficult at best. She complained about everything in the office. It was either too hot or too cold. I'm like, you have your own temperature control in your office. Well, it's too cold in the hall. I said, then stay in your office. I said, I don't know what you want me to do, but that's the hall. I mean, I can't really regulate it. I don't like this, I don't like that. She was the most negative person you'd ever meet. It was exhausting for me. And so when she finally went home, and when she was the first person I knew to get COVID. She got it like February 13th. Before we even knew about it, a month before we knew about it, she had this awful flu, and she did have COVID. We just didn't know what it was. Her and one of my other partners from Northern Virginia got it at a conference, and we had no idea what it was. And she goes, I think that you have a sick. I think we have a sick building. So that's the other thing she told me. Like, we don't have a sick building. There's nothing wrong with the building. I want to move from that building. I think we should move. You should get different space. If you get different space, I'll come in. So we moved. In October of 2020, moved to a different building. She never came in. Loved the building. Glad we moved. I'm perfectly happy to move. So really productive. And so the lesson I'm trying to give you is people can be very productive not being in your office. And as much as you want to control who's in your office, think about whether you need to control it. I changed the whole way I manage people after 2020. I've taken a much different approach to folks. It's a much more, it's less me micromanaging and more me putting on them, just get your stuff done and be productive. And if you are, I don't care where you work. So some people can't do that. Some companies can't. If we were manufacturing widgets, yeah, they'd have to come in. But we're not. So we have the technology to do it, so we should do it. The employer doesn't have to provide the employee the requested accommodation, excuse me, just a reasonable one. We always get hung up on, and employers do this all the time. They will call me and say, hey, the employee wants this, 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 and this. And I'm like, okay, well, is it unreasonable? Well, yeah, I mean, we can't do this. I mean, they'll come up with a whole bunch of reasons. Well, it might be very easy for them to do it. It's really not unreasonable. A client, last week called me and said, hey, I have a sight-impaired employee, and she wants a larger monitor. I said, okay. I said, what's the problem with that? Well, nobody else has a larger monitor. I'm like, okay. I said, but who else is sight impaired? Nobody. And she wants a monitor the size of the one you can see in the middle part of the room. Now, that's huge. It's a big monitor. But she does accounting work, so she can't see. And she needs the monitor so she can blow it up more on them. And they said, well, that's just going to be really annoying. When we go into her office, we're going to see this monitor with this big thing of numbers on it. I'm like, annoying to who? I said, why do you care? I said, how much is the monitor? $250. I said, so spend the money. And I got this huge fight. I billed them for an hour because we fought about it for an hour. So it's kind of dumb on their part. My billable rate's $450 an hour, so they pay me $450 over a $250 monitor, which was stupid. And so it's just dumb. So now it cost them, what, $700 total? You could have gotten a much better monitor for $700. Those are the things people fight about. Now if there's a reason for it, if somebody wants, I want the brand new iPhone because it's got a better alarm on it or something like that. You don't have to do that. I mean, that's silly. And there are people that do that, but they're few and far between. The employee does have to ask for the reasonable accommodation. Now, they don't have to use magic words, but the employee has to engage with the employer to ask for the accommodation. Now, if the employer doesn't know about the disability, there's no liability. So if you don't know, you can't be liable for it. So a lot of employers, that's why as an employee you want to put them on notice that there's an issue. And there's no requirement that an employee disclose an invisible disability unless they want a reasonable accommodation. So tons of people with invisible disabilities never disclose them. They don't want anybody to know. They're not looking for a reasonable accommodation. And so at the end of the day, you don't have a right as an employer to know it anyway. The HR people usually do know because they see on the benefit stuff, they can see what prescriptions you have. They have to keep that all confidential. They can't put that out there. But most people don't know unless you tell them that you have an issue. It's not going to happen. So if you're going to have an issue and you want to tell the employer, then get together and have that interactive conversation. And it should be interactive. It shouldn't be one-sided. It shouldn't be the employer telling the employee what's going to happen. It should be the employee helping and saying, here's what I need, and the employer going back and forth and talking. It's what should be happening in that process. You don't have to make an accommodation as an employer if it creates an undue hardship, but I can tell you most things are not undue hardships. I hear this from my employer clients all the time. They know the buzzwords. I love when people Google. Now with AI, everybody can be a lawyer because you can just put something in AI and say, tell me what an undue hardship means so I can call my lawyer and know. And so I'll get people that'll call me and say, well, I went on AI and I know everything there is to know about the ADA. I said, really? I said, you do know that AI is about 4 years behind, right? Depending on which one you used. And they're like, what do you mean? I said, they only have information up to like 2020. They don't have stuff in 2024. Now, you can buy it to the ones you get, but the ones that you get for free, they're not as great as you think, so you got to be careful. So an undue hardship standpoint, we'll go to that in a second, but there's very few things that meet it. So let's see what it is. So here's what undue hardship is, and here's what you have to look at as an employer to figure it out. What's the nature and cost of the accommodation, the employer's overall financial resources. If you're a multi-billion-dollar company, you're going to have a hard time arguing that you have an undue hardship. The number of people you employ and the effect of the reasonable accommodation on your expenses and operations. So I can give you a good undue hardship example. I represented a bunch of hotels back in the day down in Miami. So this is back before South Beach was anything big. South Beach used to be just a bunch of old hotels that were kind of cool but not accommodating for people with disabilities. Still aren't. And so what happened back when the ADA first came out on the accommodation side, a group of folks sued a group of these hotels claiming, hey, you're not accessible under the ADA. And the argument was it'd be an undue hardship for them to do it because they would have to gut the entire interior part of the hotel to make it accessible. That makes sense to me. Now, it doesn't make sense to somebody that's in a wheelchair. Because like, well, then I can't get around that hotel. And what the court said is, it's too hard, they can't spend $5 million on a property that's worth $2 million to gut it and make it accessible. Now, that's a rare instance where that happens. That's a true undue hardship. Most of the things in the employment world don't qualify on that in undue hardship analysis. Direct threats, the same thing. Now, you can deny somebody with a disability a job, or you can terminate somebody that's either a direct threat to themselves or to others. Again, it's got to be a significant risk to health or safety. And I gave you an example here about a nurse that has Alzheimer's. Now, if her condition causes her to forget to administer patients' medications, she's a direct threat. That person we can take out of the nursing job. In fact, you don't want that person in the nursing job because she doesn't remember what to give. Now, again, it's rare that we see direct threat, but it is out there. And so people, always tell me it's direct threat, undue hardship, we don't have to accommodate. And I'm like, yeah, you do. 99.99% of the time, you don't have either one of those. All right, let's talk about some invisible disabilities and self-advocating for those and how we kind of get through that. So some examples, and we've given you some already: chronic pain disorders, learning disabilities, mental health conditions, autoimmune disorders. There are more. I couldn't possibly give you every invisible disability, but I'm going to give you the ones, the big ones that we can talk about. Here's some misconceptions that people have. Invisible disabilities are always, invisible. Well, that's not true. Some of the symptoms may not be apparent, but then that still means that they're having an impact on the person's life. Here's the other one. People with invisible disabilities should always disclose them. No. If you want to disclose it and you want a reasonable accommodation, fine, but a lot of people would rather keep their privacy and don't want people to know that they have an issue. So you don't have to do that. Visible disabilities are more valid than invisible ones. That's false. Any disability is valid. If you're not obviously ill, you don't have a serious disease. Well, that's not true either. People can have a number of issues going on with them that doesn't show or present as being obviously sick. So that happens, quite often. So how do employees self-advocate for themselves? And this is the thing that, I wish I was talking to more employees. I know you all are employees of somebody, but most of you are in management. But people know they need to know their rights under the ADA. It's a difficult statute at the beginning to get through, but if you just stick with it and read through it, it starts to make some sense. And those that know their rights do a better job with the employer, because then you can assess your own needs and be ready to argue with the employer about what your reasonable accommodation should be. And if you can present a good argument to the employer, most of the time you're going to see people make that accommodation. And so, but you're going to need to advocate for yourself. And a lot of employers are like, well, they should just give it to me. I shouldn't have to advocate. You have to advocate for yourself to be able to get it. Prepare documentation. Gather medical records, gather other documents, other things that you need to prove what you need to prove. And the pushback I get from employees all the time is, I shouldn't have to do that. I agree. You shouldn't have to do that. But if you want to advocate for yourself and you want to do it in a good way, this is a great way to do it. So I'd rather be prepared. There's a lot of things you don't have to do in life, but if you kind of want to get through and not be aggravated all the time and angry all the time about it, if you advocate for yourself, it's the better way to go. And then initiate that interactive conversation. Don't wait for the supervisor or HR or somebody from the employer to do it. Initiate it. It's a great idea for you to start the conversation. It's extremely stressful for an employee to do that. And I realize that. The employer is not going to necessarily know exactly what's going on. So if you at least start the conversation, then at least you can get going on that conversation. The HR folks should understand what to do next. A lot of them don't. So what we try to do in the training that I do for the employers is teach them and teach the managers how to be more empathetic, how to be more proactive, and how to get this stuff to the human resources folks. I should have asked that in the very beginning. I didn't know who I had, but this is good. So when you're doing it with your supervisor or HR, I like the interactive conversation to be with HR. And that means you've got to have good HR folks that are approachable. And those in HR and those that haven't been in HR, we all know in my career, we've had HR people that are not very human, a part of the human resources part. And they're out there. They're not usually the easiest people to talk to. And so sometimes you need to go to your supervisor to get your supervisor to come advocate for you to HR. It shouldn't be like that, but sometimes it is. Most HR folks are great. My wife is a former HR person, so I can make fun of HR people. I was in HR for a year, which drove me to go to law school because it was such a horrible year being in HR. I'm like, I don't want to do this, and I became a labor and employment lawyer. I thought I was going to be an environmental lawyer or a prosecutor, but no, I became a labor and employment lawyer, so I do super HR stuff. Didn't get away from it. How do employers promote disability inclusion? So a lot of this needs to happen for employers. So if you want to take this training deck back with you, you can. And use it in your employer, in your place to train folks, but you really need employers to promote it in the workplace, because if it's a disability-friendly workplace and people understand that, this is going to help the whole piece kind of kick off. So you should be company-wide training to educate folks so they understand disabilities, understand empathy. A lot of people are not empathetic. They're just not. Now you're going to say, well, what do you mean? And I care about people. A lot of people don't. And at the end of the day, they tell you they do, but they don't. And so, we see that in our society today. We're seeing all kinds of divisive stuff in society today. I'm hoping it gets better over time. But in the workplace, we should have some empathy for folks and promoting inclusiveness for folks. A lot of times there's just battle lines drawn in the employment relationship. And people are very much with blinders on. It's like it's all about me, and they don't really care. And I'm hoping that more of this training we can do for folks, we can help even that out a little bit. Building a sourcing retention plan. So you should actively be recruiting people in your employment relationship that have disabilities. That should be part of your strategic plan, because the more you do that and the more that you're able to get folks in, it takes away the whole issue within the company of there's something different about people with disabilities. There's not. But if you don't do enough of this type of training, people don't know it. Provide support. Again, we talked about flexible work arrangements is helpful. Job sharing is great. Part-time schedules. I've got a job now I'm about to open up that's a part-time legal assistant job to help my legal assistant who doesn't have a job description that's in date. She needs help. We're going to have a part-time legal assistant job for somebody so that they can help us. Accessible workspaces, assistive technologies. There's a ton of stuff on the technology front that can really help people. So it's helpful if you're able to do those. Offer EAP. There's not enough talk about the employee assistance plan, the program that you have. And that's a helpful piece as part of your benefits for folks. Communicate your disability inclusion plan and then measure the return on investment. So you need to actually measure it, not just have plans that don't work so you know if it's going to work. Now, how can coworkers help? So coworkers need to educate themselves under the ADA as well, and they need to avoid unconscious bias. Now you're going to say, what's unconscious bias? I don't have any unconscious bias. There's nothing biased about me. I'm a great person. I can guarantee you have some unconscious bias, and we'll talk about it because I want to kind of give you what unconscious bias is. So let me give you the definition for it. So unconscious bias is a social stereotype about certain groups of people that individuals from outside of their own consciousness are aware of. So let me give you an example of how you have unconscious bias. And we'll see if you do, and I can tell if you laugh, because then I can tell if you have it. If you see somebody that has a Trump sticker on their car or a Biden sticker, you have an immediate reaction, probably. Unless you're just completely clueless and don't care about politics, which is okay. If you can live in that world, and I've got a friend that lives in that world, I call it Greg's world. Greg lives in his own world, and he doesn't have a clue about much of anything. But when you see somebody with a Trump sticker, your immediate probably thinking you're going to be thinking, or a Biden sticker, I'm not going to tell either one, I don't like that person. And you don't know them from Adam. But you've already decided the person in that SUV in front of you that has one of those stickers on their car must be really dumb. And that's not true. But you already have an unconscious bias against that person. I have unconscious bias against people that have Dallas Cowboy stuff. Can't stand Dallas Cowboys. I think anybody that roots for the Dallas Cowboys has something seriously wrong with them. Of course they don't. But my immediate bias, if I see the Dallas Star is, they go down a notch in my whole, I'm like, no, is that right? No. And then once I get to know them, it's no big deal. But it still annoys me when I see Dallas Cowboy stuff. Now, that's an unconscious bias. So think about that, and you got that in the workplace. So if you've got unconscious bias, think about how many biases you have against people you see in the workplace. And you do. Now, can we fight those off? Sure. Can we mitigate them? Absolutely. But you have to know that you have it when you first deal with it. So just know that unconscious bias is something that's out there, and coworkers have it, so do everybody else. Coworkers need to be respectful and empathetic. Active listening is important. Most people do not actively listen. Think about how many times you talk over people. How many times do you, in the day, really actively listen? Most people don't. Most people are so concerned with what they're going to say to what you've just said, or what story they're going to tell to one-up your story, they didn't hear half of what you said. So if you'll try doing more active listening and less talking, it's actually helpful. It's hard, because that's not how we all interact. And so, it's difficult to do it, but the more you listen and the less you say, the better off sometimes it'll be. I was dealing with, and a couple years ago, I was seeing somebody, I was seeing one of these counselor folks to help me, because I was dealing with a bunch of issues with my parents. And we all have issues the way we were raised. I'm sure my parents are wonderful people. I'm going to go see them after this, because we're heading over to Harrisonburg for a meeting, so I'm going to stop in Stuart Straff, Virginia, and go see my parents. But you from Stuart Straff?
I graduated from Stuart Straff High.
No, I went to Wilson. I grew up in Fishersville.
Yeah.
So, yeah, I know. See? You already have an unconscious bias. See? Hers isn't even unconscious. Hers is just blatantly conscious. It's like, hate those Green Hornets from Wilson Memorial High School. Yeah, I hate the Cougars from Stuart Straff, too. No, I'm just teasing. My parents live right across the street from the high school in a brand new development that's over there. And so, I was seeing somebody about, how do I deal with the issues with them? They won't listen to me. They're getting older. I'm trying to get them to go into assisted, all the issues you have as you have parents that get older. And she said, why don't you try not trying to solve everybody's problem? And I said, yeah, but that's my job. I'm the oldest. I kind of have to solve everybody's problem. My sister's not going to do it. I said, she's the younger sister. No, she's wonderful. She's actually caring for them 2 days a week, because she lives in Stuart Straff. She said, why don't you do more active listening and less talking? She said, it would do you good, and she was good. She's pretty good. I see her every once in a while. I do little checkups with her, because she's good at checking me and putting me in my place. And she said, if you just listen more, you might get more out of this. Listen to what your parents are telling you. So I did. And I finally said to them, what do you want? And they said, we want to die in this house. And I'm like, okay. I said, but do you want to get help? No, we don't want any help. I said, well, my sister, her name's Sherry. I said, Sherry can't care for you. As you continue to get older, you're going to have needs that you shouldn't have your daughter taken care of. And they're like, we want to die in the house. I'm like, okay. I said, I'll never mention assisted living again. And I haven't. So I'll go today. They both need to be in assisted living yesterday. They cannot navigate by themselves. If my sister would move away from there, they would be sunk. But you know what today we're going to talk about is anything other than assisted living. And what they do is they talk about everybody else that needs to go. So as soon as I go, I know what I'm going to hear. Janie needs to be in assisted living. She can't care for herself. I'm like, I won't say a word. I'll say, you're right. And that's all I'm going to do. So we got to do more of that active listening, less trying to fix stuff. Offer assistance when appropriate. Folks with disabilities don't want your assistance unless you think it's appropriate, or unless you can tell that they need it. It's perfectly fine to help, but if they want to be autonomous, leave them alone. And a lot of people do. They do not want you to intrude. But it's nice to be able to offer it if you're good enough friends and that person wants you to do so. And here's another way you can support it. So be mindful of the language you use. Don't call people handicapped. I mean, people still do it. My parents do it, but they're 86 years old, so they're still going to say things that are offensive. But it's a person with a disability. Avoid using derogatory or stereotypical type names. Include them in social things. I had a call yesterday from one of the employers that said, "Hey, I've got somebody that's disabled, and we have some overtime coming up, but I feel so bad for her, I'm not going to make her do it." And I'm like, "What?" I said, "What do you mean feel bad for her?" I said, "She wants the overtime. She wants the work." I said, "Everybody's included. Everybody in that group should be included. You shouldn't be singling her out because you think you know best." You're like, "Well, I never even thought about that. I thought I was doing a good thing." I said, "No, you're doing the exact opposite thing. You're not doing a good thing. If for some reason she comes to you and says, 'I need a reasonable accommodation because,' that's a different story." But I said, you don't exclude her from things like that. Advocate for inclusion. That's what your coworkers should be doing. If your coworkers are buying it and are buying into it and are asking you to include folks with disabilities, it's going to make it a lot easier in the workplace because now you have an inclusive workplace. Yes, ma'am.
Thank you. I don't want to interrupt you at all.
You go ahead.
On this, but I wanted to make a statement about language because disability language is evolving quite a bit, and person-first language is appropriate if you don't know. But there's a lot of identity-first language and disabled person as opposed to person with disability.
Okay.
So when you were saying listen to how the person identifies is important because it's, I grew up on person-first language. So it was difficult for me to say, what? That's different. Just like hidden disability for me is not appropriate, I would say non-apparent. But if you have a hidden disability and you want to say it, then it's fine with, I have nothing to say because you described how you are. And your parents can say handicap if they were, well, they'll say it anyway, just like mine did until I taught them. But if the person considers themselves using that word, then you don't want to correct them.
I don't.
No, you can't.
Oh.
I mean, if they were in truth truly disabled, but they called themselves handicapped.
Right. Then you leave it alone.
If you're 20 years old and you say it, it's still okay.
Yeah, you leave it alone.
So I just wanted to say that language is evolving a lot around this community, and listening, active listening, is how you know how the person prefers to use that language.
It's a good point. Great point. Everybody can hear that? Yes? Okay. You have a microphone or something because I can hear you like in the speakers.
Because I have a microphone.
Oh, because you have a microphone. I didn't.
On my microphone.
Oh, I didn't even see that. Okay, cool.
And I'm not recording you, but I'm watching your captions on my phone.
You can record me if you want. I don't care.
No,
I assume everybody records me. That's what I tell my clients. I said, anytime that you're talking to an employee, assume you're being recorded. That has nothing to do with this presentation. I'll just tell you, assume everybody records you because they do. So if you assume you're being recorded, you'll be careful what you say. Or maybe you won't. But assume you're being recorded. Virginia's a one-party consent state, meaning the person hitting record, that's the only person that has to consent. So you can be recorded for anything. So I just assume I'm always being recorded. But hopefully that's working on the closed caption thing. Cool. All right, so let's conducting the interactive process, and we'll get into some specific disabling conditions. So the employee has to ask for the accommodation. They don't have to use those words, just exactly. And then you should discuss and explore how it all works in terms of the essential functions of the job. You don't have to make the accommodation, again, if it's an undue hardship or direct threat. And you can get information about the employee's medical condition if it's not obvious. But again, if the employee comes and says, look, I need an accommodation, and it's not obvious what it is, you're entitled to ask. You're not entitled, though, to get a bunch of their medical records. You can only get something that's associated with the disabling condition. That's it. So you've got to be really careful when you start going down that road. That's why I don't like supervisors normally having these discussions. Because what happens when supervisors do it is they get too personal and too familiar with people. And then they'll say, well, what else is wrong with you? And they'll start asking those types of questions, and then that becomes a violation of the ADA. That's why I like HR people to do it. So recognize the need for an accommodation is the first thing you do. The employees, if they've communicated a need, that's fine. If they have, you should document that request. I'd like to provide people with a formal way to do it, if you can. I think things in writing are better than just verbal. And if somebody comes in and only wants to verbally tell you something, and you're an HR or you're a supervisor, then you should send an email back to that person confirming what you just talked about. And you're going to say, well, I have enough to do. I don't have time to do that. You take time. Take the time to send back an email, because sometimes what you've heard, you didn't process the right way. You'll say, well, how's it my fault? Well, because a lot of times you you interpreted something that they didn't mean. That's why I always like to put stuff back in writing to people and say, can you confirm if I got it right? It's a good practice for you to do on just regular stuff in the employment relationship. If you're documenting performance issues, you should always, when you're sitting down and talking to somebody, send an email confirming what you talked about. For a variety of reasons. One is to make sure that the person actually heard what you said, because remember, it's scary to talk to you. If you're an HR or you're a manager, it's scarier than you think it is to have that conversation. Most people don't want to have it, and so most of the time they freeze or they don't hear everything that you've said to them, and they may not remember what they said to you. So send it back to them in some sort of email or a standardized form. I like doing that for folks. Consider FMLA issues. So if you have 50 or more employees, you're covered by the Family Medical Leave Act. How many in here are covered by FMLA? Is it everybody? No, not really not. Okay, so it's not a ton. So we won't spend a lot of time on FMLA, but if you're 50 or more employees, then this person does have a right to job protected leave. I started off the presentation talking about that with the example I gave you with the person that had it, and we were trying to give that person the FMLA piece to help them keep their job, even though they weren't really sure that they wanted to keep it. Gather information, locate their job description, consult with their manager, find out what job duties may not be in the job description. If you have an ADA questionnaire, you should give that to them to complete, and then set a deadline for them to get it back to you. Now, the ADA does not have deadlines in it like the FMLA does in terms of getting things back, so you have to set deadlines internally with each other. But be flexible. If the person can't get the medical records back because the doctor won't call them back, don't just immediately say, hey, I got you. I gave you 5 days, you didn't do it, it's day 6, let's fire you. You shouldn't be doing that. Work with them if you can. Consider alternatives. So here's some specific conditions. So, we've got Alzheimer's disease and dementia. So here's some things that people may need. I'm not going to give you all these because you've got them in writing, but a lot of people need a quiet working environment. And this goes back to remote work. If they can do their work and they don't need to really be in your place and they don't have to hear all the noise coming in your place, it might be easier for them to have a working environment that's quieter. I've got an employee that has ADHD. She's came to me and said, look, I can't sit out in the cubicles with everybody else because I'm so distracted. Can I have an office? Now, you would have thought if I gave her an office that everybody else would revolt. They didn't. I said, sure, I'll put you in an office. We have an extra office. You can close your door when you need to close your door to focus. I said, I want to give you the space you need to be able to do the job you need to do. And I talked to the other legal assistants. I didn't talk about, I said, in the end of the day, she actually told them why. So I let her do it if she wanted to do it. And then I just said, are you guys fine with it? And they're like, yeah, if that's what she needs to focus, let her have an office. None of them were like, gee, I want the next office. They didn't really care. They're like, we understand. Providing calendars and to-do lists. There are certain people that need to have that type of thing. They're not self-sufficient or they can't focus on these types of things. Now, my dad has got early onset dementia. We knew it was coming about a year ago because he has hydrocephalus and he's not well enough to have it operated on. So he really needs a shunt to drain that fluid, but he's just not able to do it. So they told us what's going to happen. He's going to continue to spiral down, and at some point, it's not going to be good. And he told him that. And last year, he understood it. So when we did this in May of last year, and I went to the doctor, and I had the doctor explain it to him, and then I told him what the doctor really meant, he got it. We've had a discussion recently. He has no idea what took place a year ago. Doesn't remember seeing the doctor. Seems to be in a really good place. So we don't talk about what's going to happen. It's going to happen, but at the end of the day, there's no reason to upset him about it. But he still remembers, certain things. He forgot my mother's birthday this year, which was a bit, depressing for my mother. And it was troubling because I'd just gone the day before her birthday to take them out to breakfast to celebrate it. And he knew it that day, but the day of the birthday, he forgot. So, as I said to her, I said, you were going to continue to have those issues. You have that at work, the people that have these types of issues. So that's why we give them to-do lists. That's why we give them calendars. That's why we really help them in terms of the way they do their work. Autism, a couple things. Organizers to structure the job will help. There are things out there. I use Smartsheet at my office, which is wonderful. It's a database that allows everybody to be in at the same time, and you can put tasks out there and build them out. That'll help people with that. If you've got, reducing idle and unstructured time is helpful for folks that have it. Epilepsy. Photosensitivity is a thing, and so is chemical sensitivity. I hear people make fun of that all the time. I can't believe those lights are really bothering you. Well, it does. It does bother certain people. People do have a hyper or chemical sensitivity where you can smell things that other people can't smell. It's a true deal. So at the end of the day, there's ways for you to have a flicker-free monitor. And you can say, well, my monitor doesn't flicker. It does. What you don't see it because it doesn't bother you, but it flickers all the time. Frequent breaks. A lot of people need a lot of frequent breaks, so you should be able to give them frequent breaks in between that. And job sharing, having flexible hours, let them work at home at different points is going to be helpful. Multiple chemical sensitivities, I just mentioned, having a fragrance-free workplace is helpful. I can't stand those candle companies, so anytime I'm in the mall, which is infrequent, I can tell you very infrequent unless my wife really wants me to go, which is rare because I complain the entire time that I'm there. So I'm usually allowed to stay in the car and not allowed to come in the mall. But anytime I walk by Yankee Candle or one of those places, it drives me nuts. I can't deal with that stuff. Same thing if I'm going through Macy's and they're squirting perfume everywhere. It's awful. But you can have that at work. A lot of people wear more cologne and more perfume than they possibly should at work, and that can cause problems. So if you've got that, we should have scent-free meeting rooms. There's a variety of things we can do to avoid that for folks. Good air quality, you can actually have a different air piece you can put in. There's definitely portable air pieces you can bring in that are relatively cheap as well to clean the air. Pain and anxiety disorders. So, there are stress management techniques that folks that have pain and anxiety disorders learn. You should know how those work if you've got people like that. A support animal at work can work. Now, I hear tons of people saying, I don't want to allow that, and we shouldn't do that, and look into it before you say no. And that dog's going to be a problem. They're not a problem. They're trained on how to do this. So, think about whether or not you can do that for someone if they need it. All right, let's go through our case study because I know I've got to give you some time to ask some questions, and I didn't give you any time. So start asking questions now because we have about 10 minutes. We're going to do my case, but if you've got questions while I'm doing my case, great. I'm going to try to go through the case quickly so that we at least leave some questions for you or some time for questions. And I can stay a little. If you need me to stay, I can stay too. All right, this is the Bell versus O'Reilly case. I won't go through a ton since we're short on time, but I want to give you at least the highlights of this case. So this is a manager in an auto parts store that has ADHD, Tourette syndrome, and major depression. And this is the part where HR messed this up. And the other people. So it's not just HR I'm dumping on, so don't feel bad if you're in HR. So this guy, Mr. Bell, his doctor proposed a schedule change for him to work a 45-hour week with the ability to work more hours. Now, what O'Reilly's didn't like is you know what? We don't do that for our store managers. Our store managers must be available 24/7. That's their rule. Well, that's the rule in most of these places. But they weren't willing to listen. And this is the active listening part. So what he said is, look, if necessary, I can work more, but I had kind of a breakdown. And at the end of the day, I just need this in place if we can have it in place. And there's not an hour requirement in their whole job, but they had a nurse practitioner that got with him. And so the nurse practitioner worked with him and sat down with him. So on, this is slide 43, and what the nurse practitioner said is, look, he's not limited to just 45 hours. What we're trying to do is put a schedule in place that says he's not going to work more than 45 hours unless needed. And they misinterpreted what she said. So HR and the company said, well, if you have a 45-hour work week limit, he can't possibly be a store manager here. It's not what she said. She said the accommodation was give him a 45-hour week, and if he needs to work more, he can. So it was no change. All he needed to know is that he had a 45-hour week because mentally he was able to handle that knowing 45 hours is where it ends. If he knows that's where it's going to end and it actually goes over, he'd be fine. But the company said, no, we're not going to do that. And they said, we're denying that. We're going to deny your request, and we don't think that you're a qualified individual with a disability because you can't work all the hours we want you to work. And he's like, I just told you I could. My nurse practitioner told you I could. I just need you to have me scheduled for 45 hours, and then I can work more hours if need be. And they said, no, that's not how it works. It's incompatible with being a store manager. And so they demoted him. They made him an assistant store manager, and he sued. And so the court went through a couple things. So they went through a failure to accommodate analysis is the first thing they looked at. And so he's got to prove he's disabled under the ADA and able to perform the essential job functions with or without a reasonable accommodation, and that they knew about the disability, and they didn't accommodate it. Well, they agreed he was disabled for the purposes of at least part of the case. And what they fought about is he was not a qualified individual with a disability. And the court disagreed. The court said, look, it's up to a jury to decide this. We're going to have a jury look at whether or not he's a qualified individual with a disability, and at the end of the day, he could do the essential job functions based on his request, just only have the 45-hour piece in there, but at the end of the day, he said he could work more hours. Now, a jury gets to decide whether or not you made the right decision. On the failure to accommodate, he argued that he didn't get a reasonable accommodation. And so the court looked at a couple things. Was his proposed accommodation feasible and would it allow him to perform the essential functions? Was the accommodation request sufficiently direct or specific that they were on notice of it? And the answer is yes. He gave them the ability in terms to accommodate him, and they just absolutely said no, without really understanding and listening to what the nurse practitioner said. And they didn't do the right analysis. And he said, if you give me the accommodation, I would have been fine. I could have done whatever I needed to do for that job. In fact, I continued to do the job. Even as an assistant manager, he was doing the job. So the court said there's enough here for the jury to look at it. Then the court looked at whether or not the interactive process was done correctly, and the court said it's a jury question, as the jury gets to decide whether or not HR and O'Reilly's did this right. And what they looked at is that the interactive process was done by field employees, not HR people. And at the end of the day, they never got a bunch of their HR people involved until it was too late, and the field managers and the field folks had already made the decision he wasn't qualified. So, we had that issue, and so the court said the jury gets to decide whether or not you engaged in an interactive process properly. And the same thing on the discrimination side. The court looked to say, hey, look, the jury gets to come back and take a look at whether or not he was discriminated against because he had a disability. We think this case settled. So I don't know what happened to the case. I never saw the case again, which usually indicates that somebody wrote a check and it went away. That's probably what happened, because otherwise we would have seen this thing come back. All right, so it's 12:54. I wanted to hit you with at least that's the Bell case. He had hidden disabilities. They didn't treat them well, and how could they have fixed it? The easy thing, let me get to the fix part, because the fix part, I think there's a lot they could have done. If the managers didn't handle it, and HR did handle most of it, it would have been fine. When HR did handle it at the end, it wasn't helpful because it was too late. But if they would have just listened to the guy and listened to what the nurse said, they wouldn't have even been engaged in this. He would have still been the store manager at the store, and they could have at least tried it. What I say to my clients all the time is, what's the worst thing that can happen if we try? Why wouldn't you just try the schedule? If he failed, you could fire him. But why not give him the 45-hour work week and then put more hours on him if you really needed him to, and see if he could do it? If he really couldn't do it and the store suffered, he doesn't get to be a store manager because it's not a reasonable accommodation. But they didn't even try. If they would have tried, you would have never had the Bell case. You would never have me talking about the Bell case. You'd never have your name used. Now, every time I see an O'Reilly's, I can tell you this, I do have unconscious bias. Every time I see O'Reilly's, I'm like, I'm going to Advance Auto. Because it annoys me that they did this in this case. I do the same thing with there's other, well, you don't care about that. I was going to say there's other people out there that I look at that are in the commercial space that annoy me that I won't go to. But I won't give you that because you don't care. Let's get to some questions you might have. So anybody have any questions on this? You got the conclusion. We were talking about navigating disabilities. I think we've given you a good path to do that. Have empathy, have understanding. If you only remember one thing from this, active listening. Try it in your personal life, try it in your professional life. It works wonders. Been married 39 years next week. I do actively listen, or at least I act like I'm actively listening, which is helpful. All right, any questions I can help you with? It's got about 4 or 5 minutes for some questions.
I have one.
Sure.
So I'm with the Department for Blind and Vision Impaired, so I'm working with people who are looking for employment.
Mm-hmm.
I hear a lot of times that we talk, I'm not sure how to even articulate my question, but is it common knowledge when someone does file an EEOC complaint, like does that follow them? Does a future employer or current employer have privy to
No.
that?
No. So the question is, if you file a charge of discrimination with the EEOC or with the state, do other people know you did? No, because it's private unless you tell people. I mean, the big problem I have for people that file them is they run around, they talk too much. So they tell everybody they filed a charge, or they put it on social media that they filed a charge. But no, it's a confidential private process. Nobody knows you filed a charge, ever, unless you tell them. Any other questions you might have? Yes, ma'am.
I have a question. So it's a little different from like my question. Obviously here, someone at the company spoke with the medical provider, which outweighs the documentation. But what happens in instances where you have a document that says someone can't lift heavier than 10 pounds, but the associate says I can, and you can't get in touch with a medical provider? What is required of the employer at that point? It's
tough when you're going to ignore the doctor, but you can. I don't like to do that because you have a written document that says they can't. What I always encourage the employee to do is to see another medical professional if they really claim they can lift more than 10 and they can get the restriction lifted. But I always like to be bound by what's in writing, even though it's annoying. Any other questions? We got 2 more minutes before 1, but I can stay longer if you need me to stay. Or if you don't have any questions, that's okay too. Yes, sir.
So we've talked a lot about when there's an employer-employee relationship. How much of this is applicable to people that are applying for jobs? Asking for accommodations from the interview, getting materials that are in media that's appropriate. How different would that be? I realize that there's not a contract,
right,
but just curious as to the way you approach that.
Same rules apply. I didn't cover it because it doesn't come up much in my line of work, which is surprising. I don't get a lot of the interviewing issues come up. It's mainly employer-employee type issues that happen. You're still able to do it, and you're still able to ask for those accommodations. A lot of people just don't. Because they're afraid if they ask for the accommodation, they're absolutely not going to get the job. And so they never ask. And so, yes, you're entitled to use everything we talked about today applies on the interview side of things. So you're able to ask for all those types of accommodations. But that's where I see in the reality of it is most people won't do it.
I didn't 45 years ago.
You did or did not?
I did not.
Right.
I've been in the chair for that.
Yeah, most people won't.
45 years ago, there was a little bit of a different environment.
Oh.
I would have to say it's improved.
It has improved, but it was a massive bias 45 years ago. It wasn't unconscious bias, it was just out and out bias. It was not even, nobody hid it, which, at least now I think we have evolved. We have a long way to go, but we have evolved. Any other questions? It's 1 o'clock. Yes, ma'am.
So on the flip side of that statement, what implications would there be as an interviewer to ask someone, are there any accommodations that we need to make? Is that acceptable or is that?
Yeah, see, I don't ask it that way. What I always give them is, here's the job. Are you able to do this job? Are you able to do the essential functions of this job? Or is there anything you need? I just kind of leave it. I don't even talk about reasonable accommodation. I'm like, can you do this list of things? And if not, is there something we need to talk about? I try not to say, do you need a reasonable accommodation? Because I don't want to put them off. And what most people that are good with this will say is, here's what I do need. And they'll tell you. Or if you give them a list and they say, I don't need anything, then I don't push any further than that. Any other questions? Well, I appreciate your all's time. Hope you had fun. I had fun. Have a good one.
Thank you very much for being with us today. A big thanks to Performance Food Group for sharing their space with us and for feeding us lunch. And thank you guys so much for giving up your time. So hopefully you took away some good information. There is a survey we just ask you to fill out because we want to keep getting better at what we're doing. If there's something, if there's a topic you'd like us to cover in the future in different seminars like this, be it virtual or in person, make a little note on the back or take one of our cards and flyers off the table and just email us because we're here to help you guys, right? So we'll collect your surveys at the end and everybody have a great weekend. And again, thanks for coming.